So in all of civil litigation, it's widely known among lawyers and judges that cases are won and lost in the discovery process. And the reason this is the case is that both sides, whether they be the plaintiff in the case or the defendant in the case, engage in most civil litigation cases in fairly significant discovery. The discovery is targeted at several things. First, testing the claims of the party that brought the lawsuit, and then revealing the defenses to the person who's being sued. In the context of a foreclosure case, the same rules of evidence and procedure should apply, and so should the same rules regarding discovery. And that is that in all of civil litigation, the civil discovery process is aimed at forcing the litigants to test out their claims and assess the relative strengths and weaknesses of their claims based on the information that they receive throughout the discovery process. Now, judges are not supposed to resolve all disputes among parties. In fact, across all of civil litigation, there is an obligation on both parties, both plaintiff and defendant, to work out all of the issues and only go to a judge as a last resort. And it's expected in all litigation to work hard to resolve disputes before you get in front of a judge. Now, in a personal injury case or in any other case, you could never imagine going in front of a judge to try and work out some stupid discovery dispute without both parties having spent a whole lot of time hammering their heads together to try and resolve things. So, for instance, if one party wanted a deposition of the other, and they were trying to narrow down the scope of that deposition, if the parties had not worked real hard and real long before getting in front of the judge to say, look, we can't resolve this conflict, you would expect to find the judge just throw both parties out of the courtroom for failing to work that out. Now, what we find frequently in the context of foreclosure cases is, again, as with everything else in foreclosure, those same rules don't apply. Now, again, one of the things that sets this firm apart from many others that are practicing is we spend an extraordinary amount of resources and time on discovery in each of our cases. We have tailored down discovery over a series of years that we've been working on these things into some very, very substantive questions, the interrogatories, and we know the documents that exist, and so our discovery is very, very specific and very, very targeted. Now, early in the evolution of this practice, we did what many did, and that was we kind of used some form discovery, if you will, basic questions. But as this process has evolved and as this practice has evolved into a very sophisticated foreclosure defense practice, we have very sophisticated, very detailed, and targeted discovery. Frequently, someone will ask me, "Hey, will you share a discovery with you?" And some colleagues I will, but quite frankly, we don't do this because you don't just share discovery, because I don't want people just throwing out their generalized requests that are not very specific and tailored to the individual cases before you. Give you an example. We do not have form or pattern discovery in this office. This staff works, many staff members, myself, other attorneys, and staff on every single discovery package, and we spend an extraordinary amount of hours on that discovery, targeting very specific issues that are particular to that individual case. We take our discovery directly from the plaintiff's case, and that's a very important part. We, in fact, go down through each and every line of that plaintiff's lawsuit and try and target discovery at each and every single line of that lawsuit. And where this is so profound is that when you get the objections from the plaintiff, so we'll send a discovery request asking, please provide how you have the authority to pursue the lawsuit. We will get what we get in virtually every single case, and that is an objection. Now, the problem with that is we take our questions directly from their lawsuit. And so what I find oftentimes is we send discovery, very targeted, very specific, asking direct questions, and invariably, as a matter of course, we get back objections to every single question that we've asked and every single document that we've requested. And it's quite troubling because when you read our question, our interrogatory question comes directly from the plaintiff's complaint. So it's apparent, absolutely obvious, that the plaintiff hasn't even bothered to read our discovery. And this is, in fact, one of the most troubling things that I find in foreclosure all across the board in virtually all of our cases. Again, we spend an inordinate amount of time doing discovery properly, fulfilling our obligations to try and narrow issues before trial. What we get from the other side is they don't even pay any attention to the discovery. The plaintiff industry, the foreclosure mills, have gotten into the habit of just objecting to absolutely everything. It's absolutely inconceivable to me in any other kind of civil litigation that when a party sends over discovery in good faith, the other side responding would do nothing but object to every single question and everything production request. And again, this is another one of those things that sets foreclosure apart from all other civil litigation. If a party did that in the context of any other civil litigation, the judge would look at those responses, those blanket objections, and he would sanction the party for interposing what are undisputably bad faith objections to discovery. And yet, what we find in foreclosure is that when these issues come up, and they come up in virtually every single case, we give our good discovery, asking real questions. The plaintiff comes back with blanket objections that are absolutely nonsense and absolutely bad faith. So we'll ask, for instance, prove that you had possession of the note that was endorsed in bank prior to filing a lawsuit. That language comes directly from the appellate cases. And what we get from the other side frequently, almost uniformly, is objection, irrelevant, not likely to lead to discoverable information. We will ask for things like provide a full account history for the life of the loan. We'll get an objection, and this is really my favorite one, objection, confidential, proprietary, trade secret. Again, these are the formal standard objections that they provide in nearly every single case. Some of these mills have gotten around to the most absurd objections, which is claiming accountant-client privilege or claiming the self and critical analysis privilege. They're making up privileges. They're making up objections that have absolutely no basis in law or in fact. And yet they're getting away with it. And why are they getting away with it? Well, they're getting away with it because the courts are allowing them to get away with it. Now, rather than a court looking at those objections, which are absolutely in bad faith, and sanctioning the plaintiff, you throwing up a couple $100 fines at them or something like that, or ordering them to answer, frequently what we're being told now on the defense side of things is, too bad, you don't get to ask those questions. And again, it's just absolutely absurd. But I'm going to make one admission here, and that is that on the defense side of things, there are people that are guilty of bad behavior. The shotgun discovery that goes out from defendants is just as bad as the shotgun objections that come back from the other side. So unfortunately, because of some of the bad conduct on the defense side, and it absolutely exists, the judges have turned to become sort of negative towards all discovery from all defense. And so that's why it's absolutely important that responsible, ethical, and high-level defense practice exist, and that those that are engaging in this bad behavior on the other side likewise stop with that kind of behavior and start performing real discovery on real issues. Foreclosure cases are won or lost in discovery. And if you're not engaging in detailed, significant discovery on substantive issues, you're going to be caught flat-footed at trial. Now, the question then becomes, well, what do you do with the discovery after you get them? Well, we, of course, have evolved our practice to respond to the games that the plaintiffs are playing. And we've been very successful, especially recently, in using their bad behavior and using their bad conduct against them many, many months down the road when something is set for trial. I, of course, don't want to be real specific about that, but I can only tell you that there are real consequences for the improper tactics that the plaintiffs are engaging in discovery, but that has to be set up from the very beginning. So that's one of the things, looking at the long view. We prepare a case from the moment a client walks into the door to how that case might turn in for trial weeks, months, even years down the road. And every step that the plaintiff takes along the way is a step in our favor when it's used accordingly.